everybody, it's AG, Allison Gill here, host of the Daily Beans podcast with another quick hit for MeidasTouch. And today, I'm going to break down Judge Carter's latest ruling in the John Eastman email saga. As you may know, John Eastman sued the 1-6 committee to prevent hundreds of his emails about the coup from being handed over to them in their investigation into the attack on the Capitol on January 6th. But back in March, Judge Carter ruled that 101 of 110 emails were not protected by attorney-client privilege or the work product doctrine, and he found that one of those emails, which included a memo forwarded to Rudy Giuliani written by a guy named Kenneth Cheesebro, which, let's be honest, sounds like something Ron Burgundy would name his left testicle, and that memo outlined what they would come to call the January 6th strategy. Now, since that time, the committee has asked the judge to review an additional 600 documents to determine whether they are actually protected by some type of privilege. And late last night, we got the judge's findings on those additional emails. In his 26-page ruling, Judge Carter determined that not only does Eastman's privilege log still suck ass, but that 159 additional documents must be handed over to the Select Committee by today, June 8th at 2 p.m. Eastern. And among those 159 emails, 4 of them came close to violating the crime fraud exception, and 1 of them definitely did. The crime fraud exception is this thing that says your communications with clients aren't privileged if you're criming. So let's talk about those 5 emails first. The judge says 4 of them consider how filing certain election lawsuits might affect the January 6th strategy. And because Eastman discusses the fact that those lawsuits actually have a non-zero chance of success, and that pursuing legal recourse itself doesn't advance any crimes, the judge decides that these 4 emails are not subject to the crime fraud exception. But that 5th email, dated December 22nd, an attorney goes beyond strategizing litigation outcomes. Quote, this email considers whether to bring a case that would decide whether Pence can or cannot just throw out electors. And that attorney decides that if the courts find in favor of Pence, that would tank the entire January 6th strategy. So he recommends that the Trump legal team avoid the courts. The judge said, quote, lawyers are free not to bring cases. They are not free to evade judicial review to overturn a democratic election, unquote. Accordingly, he says this portion of the email is subject to the crime fraud exception and must be disclosed. Additionally, the court reviewed a group of 30 of the documents that Eastman claimed were protected by his First Amendment right to free speech. But the judge says 10 of these documents relate to 3 meetings that happened in the first 2 weeks of December in 2020. 4 of the 10 documents pertain to a meeting December 8th, in which a, quote, high-profile leader of a group of 8 lawyers for Trump invited Eastman to speak to discuss how state legislatures could reverse the election results. Reverse the results. Another 5 of those 10 documents pertain to a meeting December 9th, during which a, quote, sitting member of Congress discussed a plan to throw out Biden electors in the House of Representatives. And the remaining document contained an agenda for a December 16th meeting during which a Trump elector discussed the constitutional implications of 1-6. The judge says, quote, Dr. Eastman's actions in these few weeks indicate that his and President Trump's pressure campaign to stop the electoral count did not end with Vice President Pence. It targeted every tier of federal and state elected officials, unquote. Whew. And the judge ordered Eastman to hand over those documents as well, because they are, quote, narrowly tailored to some of the committee's interests. But what stood out to me the most in this ruling, aside from the criming, is the number of times Donald is mentioned in this ruling, 40 times in all, and how often the judge pairs him with Eastman. We already know from last March this judge determined beyond a preponderance of the evidence that Trump and Eastman violated federal laws, namely 18 U.S. Code 371, conspiracy to defraud the United States, and 18 U.S. Code 1512c2, obstructing an official proceeding. But check out some of the concrete connections the judge makes between Eastman and Trump in this ruling, that they worked on this together. Quote, the previously disclosed documents indicate that Dr. Eastman and President Trump's plan to disrupt the joint session was fully formed and actionable as early as December 7th, 2020. Another quote, Dr. Eastman and President Trump's plan to stop the count was not only established by early December, it was the ultimate goal that the legal team was working to protect from that point forward. And this one's just funny. It says, quote, although Dr. Eastman's privilege log claims that the photo is President Trump's handwritten note regarding issues for anticipated litigation, the note simply celebrates the size of President Trump's campaign rallies, unquote. Now, given all this information, I'm hoping the next time Donald brags about the size of something, it's his prison cell. Tune in to the Daily Beans podcast tomorrow morning for an in-depth analysis of this ruling, accompanied by appropriate profanity. My name is Allison Gill. You've been watching a MeidasTouch Quick Hit. See you next time.